I am Karthik Kumar Agarwal Advocate and you are watching my channel Bharti Law. So today let's discuss about well-known marks which are enshrined under section 21ZG of the Trademarks Act 1999. So there are certain essential elements uh, through which are defined under 21ZG that makes a mark well known. So the first and foremost element is that it should be known to the substantial segment of the society. So a substantial segment of the society should associate with that mark, should know that mark. Secondly, the that use of such mark for other goods or services should be taken as an indication to the original goods or services. For example, if we look at Tata Salt, so Tata Salt in itself is one of the mark which is associated with the Tata. And now, if we use it for some other product, let's say a soap with the name Tata Salt over it, so it would be associated as it that particular brand is that particular soap is coming from the house of Tatas. So that is an infringement over a well-known mark. Now, moving further, section 11, subsection 6 tells us certain conditions through which the registrar can identify any of the mark as a well known mark. So, the first and foremost condition is that it should be in the knowledge of relevant section of the society. It can be either through promotion or through use. And the conditions for this are enshrined in section 11, subsection 7. So the number of actual or potential consumers should be identified. Then number of persons involved in the channel for the promotion. Basically, the point number 2 is for the promotions. So the number of people involved in the promotions and the distribution of that particular product or services. And then the business circle dealing with the goods or services. So these 3 points have to be identified if it is through the knowledge of the relevant section of the society. Then now, the second essential element to determine whether a mark is a well-known or not is that the duration or the geographical area or the extent of use of that mark. So, if that particular mark is being used in a particular geographical area or that particular geography, then and up to what extent that mark is being used, then that is required to be considered when identifying a mark as a well-known mark. Then the third is that if in any of the court proceedings or any of the opposition proceedings, it has been identified as a well-known mark. This is again reiterated in section 11, subsection 8. Then it is again a well-known mark. Now, coming to section 11, subsection 9, it tells us that what we should not look when identifying a mark as a well-known mark. So, what registrar should not look at it that the trademark has been used in India. So, if it has not been used in India or if it has been used in India, that should not be taken into account. Secondly, that the mark has been registered. It doesn't matter whether a mark is registered or not. An unregistered mark can also be identified as a well-known mark. That the application has been filed in India for registration. If you have not filed an application in India for registration of a mark, then it's not necessary that you cannot apply for a well-known mark. Then that the mark has been well-known or registered or applied for registration outside India. So it is also again not necessary that you have to apply it outside India to be recognized a well-known mark over here in India. So all these four conditions can be omitted and they should not be looked at by the registrar. I hope you like this video. If you have any doubts, you can always drop them in the comment section below. If you like this video, please do hit the like button, subscribe to my channel. Thank you.